Welcome. We are still on Introduction to Law and Governance paper that was done in August 2022. August 2022, and it's a CPA CCP paper. So we are on question 4, and we'll start with the first part of question 4, which is A. Highlight 5 instances where receiving of another's goods will not amount to conversion. Highlight 5 instances where receiving of another's goods will not amount to conversion. Now, generally, receiving another person's goods will amount to conversion, but we want to look at situations where receiving of another person's goods will not amount to conversion. So we'll go straight to the point. This is highlight 5 instances, so we are simply going to highlight. Number 1, where the goods in question had been abandoned. Abandonment of property by the plaintiff. So if the goods in question had already been abandoned by the plaintiff, then in such cases, receiving of these goods will not amount to conversion because they had been abandoned by the plaintiff. So abandonment by the plaintiff will be one of the reasons. Number 2, if the goods have been received by authority of the law, that is to mean that the due process has been followed. Due process has been followed by the law. So it is law that has authorized, possibly the court has authorized that you receive another person's goods. In such cases, it will not amount to conversion because you have the authority of the courts. Then number 3, when there was consent or approval by the plaintiff. And this consent or approval by the plaintiff can either be express or by implication or implied. Especially this one. Implied is by the conduct. So if the plaintiff behaved in a manner to suggest that he has allowed you to go ahead and receive his goods, then it will not amount to conversion so long as you can prove that. So consent or approval by the plaintiff, he agreed, he approved that either through his actions or expressly, then that will also not amount to conversion because he is behind the reason why you have received the goods in question. Then statutes of limitation can also be a reason. Statutes of limitation, and a very good example here is when there's a delay in bringing the action, so that it has overstayed. You received the goods long time ago. Maybe you're talking about even 30 years, and this plaintiff has never come to complain. So we talk of statutes of limitation. The statutes put some limits that if this period of time lapses before any case is raised on, and so if that period of time that has been stipulated lapses and that case has not been presented, then it means that the other person will, having received the goods, will not really amount to conversion because of statutes of limitation. There was a delay in bringing up the action to the extent that it is now, possibly it ceases to be a conversion now. Then the other point is if there is also the interest of the defendant in that property in question. So if the defendant also has an interest in that, the goods that we are talking about, then it cannot be conversion because he also has an interest. It will be a different case altogether where they'll be seeking to possibly find out how each of them is supposed to get his or her share. But it will cease to be a conversion because he also, that is the defendant, will be having an interest in the same property. The fact that he will have an interest to the property simply means that it will not be a conversion. Then the next item is privilege to claim possession. Privilege to claim possession. If this person has a privilege of any kind to claim possession of that property, maybe has been given either absolute or qualified privilege to own that land or to claim possession of that land, then he can also, it can amount to not, it may not amount to conversion because of that privilege to possess that particular piece of land or those particular goods in question. Then you also have non-existence of the property in question, non-existence of the property, or lack of identity of the property. If you can't identify the property, lack of identity of the property or non-existence of the property. So it will not amount to conversion if you can't show what the goods in question. So if you can't identify the goods in question, you can't show the existence, then how will it amount to conversion? Conversion is only possible if you can show that these are the goods in question. This is what has been converted. So identity is very key when we talk about conversion and the existence of the property in question. Also fraud. If the goods were gotten by fraud, you know, you cannot go to court and start following up on something that was, whose premises basically are made up of fraud. Especially where the ownership also is questionable. So illegal ownership cannot basically, you know, you're going to pursue something that doesn't belong to you. That in itself is cannot stand test of time. So fraud also can be if you say that the ownership, the previous owner or the plaintiff acquired this property fraudulently, so it's not his. You know, so long as you have proof to show that it's not his, he acquired fraudulently. The whole point here is that he cannot be an illegal owner and come to sue you for also being in possession of what, you know, it's not his. So that is a whole point. These are so many points. Just pick any 5 and you'll be good to go. Let's move to part B of the question. Part B of the question. Part B of the question. Outline 5 distinctions between a promissory note and a bill of exchange. Now, all these are negotiable instruments. I think let me make use of a table. All these are negotiable instruments. The promissory note and bill of exchange. And we also have checks. So those are the 3 most common negotiable instrument: bill of exchange, and then you have the promissory note. So a bill of exchange is an order. This is an order, and that is the starting point. While a promissory note is a promise to pay. This is a promise to pay. This is an order. So that is the first point. Bill of exchange is an order, and it's an order issued to. It's an order issued to the debtor, by the creditor. Issued to the debtor by the creditor. And this one is a promise to pay by the debtor. It's a promise to pay by the debtor to the creditor. So this one is issued by the debtor. Issued by the debtor. This one is issued to the debtor. I think you get the difference. It's an order issued to the debtor by the creditor. This one is a promise to pay by the debtor. And of course, we are talking about a certain period of time, a certain amount of money. You know that definition. But these are pertinent differentiating factors. Then we also have the number of parties. For the BOE, we have 3 parties. we have three parties in a bill of exchange. We have the drawer, we have the drawee, and we also have the drawer, the drawee, and the payee. So we have the drawer, we have the drawee, and we have the payee. While in a promise or note, we have only two parties, and the two parties are the drawer, who is the maker, and the payee. Drawer and the payee. So that's yet another difference. Three parties, drawer, drawee, payee. Here only two parties, that is the drawer and the drawee. The other difference between this is that for BOE, liability of drawer, under bill of exchange, liability of drawer is secondary and conditional. Is secondary and conditional, while for the promissory notes, the liability of drawer is primary and absolute. Liability of drawer is primary and absolute. It takes full responsibility, the drawer. And here, the liability of the drawer is secondary, and it's also conditional. Drawer needs to accept BOE before payment. Under BOE, drawer needs to accept the BOE before payment. So drawer needs to accept, drawer is like the bank now, needs to accept the BOE, receive the check before he can proceed with the clearance and do the payment. While on the other side, there is no acceptance required from the drawee. No acceptance required. This side, no acceptance is required. No acceptance required. The other side, there must be acceptance of BOE before payment. Here, no accept for under promise or not. No acceptance is required. Then, what else? Trying to look if we have any other differences. In case of, let me see this one. In case of a dishonored BOE. In case of a dishonored BOE, communication. In case of a dishonored BOE, communication or notice is served to all concerned parties. Notice is served to all concerned parties. That is in case of dishonor. Notice is served to all concerned parties. And then for promise or not, in case of dishonor, no notice is served to drawer. No notice is served to drawer. So in case of dishonor, no notice is served to drawer when you are talking of dishonor. And then when you are for promise or not, and then for BOE, notice is served to all concerned parties. That's also another difference. So how many differences are these? These are 6. The question only wanted 5, so just pick any 5 and it will be good. And of course, there are so many other differences that we have not mentioned just for the interest of time, and the examiner only wanted 5 questions, 5 points, distinctions. But there are quite a number. These are just some of them. It's a very nice topic, negotiable instruments, and its questions are normally straightforward. So let's move to the next one. Discuss 5 defenses of a trademark infringement. Discuss 5 defenses of a trademark infringement. Discuss 5 defenses of a trademark infringement. Number 1, fair use. That's a fair use, where you might claim that you are just using, these are normal English words that anybody could use to define his or her product. So you can say it's fair use, especially when we talk about the descriptive fair use. We have what we call descriptive fair use, that this is just normal use of English words. It just happens that these words somehow are almost related to his trademark, but The whole point here is that it's just fair use of maybe English word, or you are just trying to communicate like any other person, especially if there's a relationship between his trademark and the normal English, the normal way of expressing oneself. So in such like cases, you can claim the fair use. Then we also have prior use, that you are using this trademark before for quite a long period of time and there was no issue, possibly, So you can also claim this prior use, that you have used this for quite a long period of time and maybe there has been no case raised against it. You are using it before, and maybe even before he registered it. So that can also be a defense to a trademark infringement. Then, of course, delay in raising the issue, delay in raising the complaint or the claim. Maybe he has, he has overstayed the limits that have been put by the law. He knew of this like so many years ago, but all along he has not he has not brought any case against it. So delay in raising the claim, that could also be one of the defenses. The other one, there's no confusion or difference, no confusion or difference, no confusion or difference in essential features. Essential features. There is no confusion or there's a difference in essential features. No confusion, that your trademark and his trademark is not causing confusion to anybody. So long as you can prove that it's not causing confusion to anybody, or there are clear differences in essential features, that can also be a defense in the trademark infringement, that there exists no confusion between the two trademarks, or that the differences in essential features are very clear. Then you can also talk over the marks are used in different markets, that the trademarks are used in different markets, This one is it might work for you or it might not work for you. It might be weak because at the end of the day, somebody might want to expand his geographical coverage. So in such like cases, this becomes weak. But otherwise, you can also claim difference in markets, that the trademarks are used in totally different markets. And that can also be a defense for trademark infringement. The other one we can use of that the trademark is not being put into use, the non-use of the mark, by the registered proprietor. So he has registered and he has not been using the mark for as long as or for as long as it takes, or he has just registered but he is not using the mark in any way. So that can also be a defense of a trademark in a trademark infringement case. The other one is invalidity of the registered mark. So long as you can prove the invalidity, that can also work. But these are how many points? These are 6 points. Just pick any 5 and you'll be good to go. Fair use, prior use, delay in raising the claim, no confusion or difference in essential features. Trademark are used in different markets, though weak, but it can still be used as a defense, especially if the markets are totally different. And then non-use of the mark by the registered proprietor. That can also be a defense for this particular case that is before the court. Maybe let me just see if we have another one. We also have this one, doctrine of lashes. I think we have said, but let me just put it. This is a timely claim for the use. A timely claim to the use. I think we have already talked about it. Delay in raising the claim. So let's just go away with it. But it could also be a point. Let me see if we can get another one. Invalid mark or registration. Invalid, I think we mentioned it, but we didn't write. Invalid mark or registration. If you can prove that, perfect. Delay in enforcement, I think we have that one. Delay in enforcement, we have that one. Unclean hands or misuse of trademark. Misuse of trademark or unclean hands. But all these things have to be proven. If you have unclean hands, that is you conduct business using forfeited rights. You know, all those can are supposed to be. But for the sake of it, I think we have the 5 major ones which we had already listed. So let's work with these 5. Okay, thank you. Let's move to the next question, which I think should be the last one for this particular question. Explain the personal liability of an agent. Now, agent is not supposed to be personally liable. An agent works or enters into contracts on behalf of the principal. So he enters into contracts with third parties on behalf of the principal. So he's not supposed to be personally liable, but there are circumstances when he will be personally held liable. There are circumstances when he will be personally held liable. Now, what are these circumstances that this agent will be personally held liable? Number 1, if he transacts in his own name. If he transacts in his own name, then in that case he will be held liable. Number 2, if he doesn't disclose the existence of the principal. If he doesn't disclose the existence of the principal, then in that case he will also be held responsible or personally liable. This one, the first one, you might wonder the difference. If he transacts in his own name, this one can be even expressly, expressly or even by implication. And then here, he just doesn't disclose the existence of the principal. And he's supposed to disclose the existence of the principal. So the fact that he has not disclosed the existence of the principal simply makes him personally liable. Then, and even just before we go to the third point, even if this is if he doesn't disclose or partially discloses the existence of the principal, then in such like cases, he might be held personally liable. Then another one, if he acts ultra vires, that is beyond his powers, beyond the powers given to him by the principal, beyond the powers given to him by the principal, then in such like cases, anything in excess of the powers, then he will be contravening the agreement and he will be personally liable to the extent of the going outside his or her mandate. Then where the contract expressly provides, that he will be personally liable. In such like cases, he will be liable. Where the contract expressly provides that he will be responsible or liable for in case of anything in the contract. Then where he transacts on behalf of, an incapacitated employer or a principal who has no capacity, capacity. By this we mean a principal who is a minor, a principal who is of unsound mind. You know, those people cannot be the law. Basically, the law looks at them with you know, that eye of vulnerability, and so they will not be. If he enters into a contract with a third party on a principal who is a minor, who doesn't have the capacity to enter into a contract, in such like cases, the agent will be personally held liable. And also, if he acts on behalf of a principal who cannot be sued, acts on behalf of a principal who cannot be sued, For example, is an ambassador, or, you know, those people who have been provided with the immunity. So if he acts on behalf of a principal who cannot be sued, then in such like cases he might be held personally liable. The same thing applies to if he works on a principal who is a foreigner, then he will be personally held responsible. And I think we can add one more. So this is a foreign principal, that one will also lead to personal liability. And the other one will be an non-existent principal, a principal who is not existent. You know, you can enter into a contract for a person who is not existent, an imaginary person. In such like cases, again, this agent will be personally held liable in case it is brought to light. How many points are those? Those should be enough. Just pick any 5 and we'll be good to go. That is the end of our question 4. It was a good question, very heavy, but make sure you answer it within 30 minutes given such like a question in an exam. So thank you. Let's meet in the next question.